And the next panel is the Maritime Dispute Resolution in Asia. And if you have not joined us on Pigeonhole yet, please do. Let's put up the QR code, shall we? Let's put up the QR code, and you'll be able to scan it and input the passcode SMW 2022, and you just have to scroll and find the session that we are in, and thereafter you can input your questions, and you can also vote for your preferred questions. And thank you to our moderator just now, John, for fielding some questions as well. And if you didn't know, this event is also live streamed on Swapcard. In-person participants will be able to network with our friends across the world virtually, our virtual participants, and all sessions will also be available for on-demand viewing later on. Thank you very much. So remember to join us on Pigeonhole to add in your votes. And after this, we will also be having lunch right here, so stay with us. Right now, allow me to introduce our panelists, and our panelists will go on to introduce, our moderator will go on to introduce our panelists. Your moderator is Ms. Caroline Young, President, Singapore Shipping Association and Chief Executive, Hong Lam Marine Private Limited. Caroline will be sharing a short presentation before she invites the panelists on stage. Caroline, please, let's give her a welcome.
Okay, great. Good morning, distinguished guests. Thank you for staying for this session on maritime dispute resolution in Asia. So before I invite my truly esteemed panelists, I want to share a few slides to set the framework for our discussion. So, So this slide shows the importance of Singapore as a global hub port and IMC. So the following are indisputable facts. 80 to 90% of the world's goods are transported by sea. Arbitration has been the preferred choice of dispute resolution for maritime sector. Singapore is a global hub port connected to more than 600 ports in more than 120 countries. Much of the world's trade actually comes through the port of Singapore, and the world's busiest container transshipment hub and bunkering hub. And Singapore has a strong ecosystem of 30+ law firms with shipping practice and 10 IGP and I clubs. So if 80 to 90% of the world's goods are transported by sea and arbitration is the preferred choice of dispute resolution, it then concludes that maritime and trade disputes would take up a substantial part of the international commercial arbitration scene. And Singapore being in the hub of it all, should Singapore be also a preferred choice of center for arbitration alongside London? But is this so? So this is the DNV Menon Economics Report 2022. Singapore has been voted as the leading maritime city of the world. Yeah. There were 6 pillars of analysis. So for today's session, I bring your attention to maritime finance and law, where it is the only pillar that Singapore is not in the top 5. We are actually ranked number 8. I bring you specifically to maritime finance and law. So they have objective indicators and then they have subjective indicators. So for the objective indicators for law, we are ranked 7 and 8 for the objective indicators, which is actually reflective of our overall 8th position. However, for the subjective indicator, which is the perception of executives in maritime, we ranked a good 2nd position after London. So you can see Singapore has performed well in subjective indicators, scoring 2nd behind London. And if I bring you to the next highlighted bullet point, the executives actually considered maritime landscape here to be top-notch, even though Singapore may not be ranked in the top 5. London, on the other hand, and that's what I want to emphasize, is by far the global #1, whether objective or subjective. And this is even true when you compare the number of cases, the arbitration cases between Singapore and London. So, you know, the gravity of trade has moved to Asia. I was told that 50% of the tonnage has moved to Asia, is owned by Asia. So therefore, the contradictions of Singapore being a major hub with legal expertise, but still very much lagging behind as a center for arbitration and other disputes resolution. So I bring this slide on because they brought in as an area for improvement, and because role of mediation is part of our topics that we're going to discuss today, they did say that Singapore should focus on mediation as an alternative remedy because they see that as increasing as we go forward. So, So today, I'm sure our experts in this panel will give us some insights to the following questions. So it now leads me to invite the panelists to join me on stage. I have first Nicholas Fell, Executive Vice President, Corporate Services and General Counsel, BW Group, and he's also the Chairperson, Documentary Committee, BIMCO Singapore. And Suin Anand, Head of Shipping, South 32, Singapore. Leong Kah Hua, President, Maritime Law Association of Singapore, and Head Dispute Resolution and Partner, Shipping and International Trade, Rajan & Tan, LLP. Karina Song, Vice Chair, Singapore Chamber of Maritime Arbitration, SCMA, Co-Chair of International Bar Association, Maritime and Transport Law Committee, and Partner, Allen and Gledhill. Last but not least, Chris Metcalf, Partner, HFW, Singapore. So thank you all for being here. And if everyone is in Singapore long enough or in the international scene of arbitration, these are the who's who in the legal maritime sector. So I don't want to go into the bios because that will take me a whole day. So I'm just going to go straight because I want them to take this time to give me their insights on some of the issues that we discuss. So, actually, this topic is very interesting. I mean, it really talks about dispute and the dispute resolution in Asia and the development of it. So I really want to have a very candid discussion. And I actually understand our session is conducted according to the Chatham House rules. So it would mean that none of the panelists can be quoted without their consent. Yeah, so now that we've gotten this out of the way, we'll dive straight to the first area of discussion, a look at the global maritime dispute resolution landscape, including recent trends and developments in maritime arbitration. So I want to narrow the discussion to the more common centers of the world. for maritime dispute resolution for international players. And in our discussion today, we discussed the centers of Singapore, and Hong Kong/London, because Hong Kong is very much a mirror of London in terms of their rules. And maritime dispute resolution is not only confined to arbitration. We have other avenues, such as the courts and mediation. However, for the maritime industry, primarily most contracts have standard clauses for arbitration. It has been said in the past that arbitration was encouraged as it was a way to bring down the costs, especially when maritime claims are usually not big, staggering amounts. However, in recent years, the costs of arbitration and the process have been said to be even more prohibitive than the costs. So I have 3 questions. Is this true? First question. If yes, why has it become so? And how can we bring that process and cost to its original intent? So maybe many questions, okay, sorry. Can I have a brief of the evolution of the arbitral process, London/Hong Kong and Singapore? And if the contracting parties are given a choice of court process or arbitration, if the subject matter can go either way, what would be your recommendation and why? Maybe I'll start with Kawa to share the scene for Singapore, and then Chris for London, Hong Kong, and thereafter, anyone just jump in? Yeah.
Thanks, Caroline, and thank you to the organizers for inviting me to be on this panel. Very privileged. I think that Singapore is really offers a suite of dispute resolution resources. So we have the Admiralty Courts in the High Court. We have the Singapore International Commercial Courts developed, right, to very recently to try and cope with this space. So in terms of courts, definitely right at the beginning and right at the forefront of these dispute resolution resources. And then also in terms of arbitration, not only do we have the administered arbitration under SIAC, we have the unadministered arbitration under SCMA, right? So I think in terms of courts, arbitration, and now, of course, right, the rise of mediation. So we have advanced mediation centers in the Singapore Mediation Center and the Singapore International Mediation Center. So I think with these resources, we are well placed to offer to users whichever route that the parties consider to be the best way to resolve your disputes, maritime, commercial, or otherwise. Right? So I think that the key infrastructure pieces are definitely in place. And the other thing is that the laws, right? Singapore laws in terms of supporting dispute resolution, right, under the various statutes, the various rules of court, the various arbitration rules, the mediation protocols, they are right up there. I cannot see that we are behind in any way, right? And in fact, the new rules of court will just come into force, as well as the new rules by SCMA, caters to what I consider to be feedback from the industry on how dispute resolution should be handled, as in like less procedures, less in terms of interference, but more in terms of control by the judges, control by the tribunals, to try and streamline issues, bring matters to a quicker resolution. And I can consider that we are really well placed to address these shortfalls in the report that Caroline highlighted. So Singapore's journey, as I would like to end, it's really has taken off, and that we hope that it will continue, and we can see in the future greater prominence for dispute resolution. Thanks.
Thanks. Chris?
Just going to the point you made about the perception that arbitration has become more expensive over time. The evolution of the arbitration process, I don't feel I'm old enough to talk about how it's evolved particularly. I can only sort of talk about, you know, my working career and what I've seen, a large part of which has been in Singapore. And I think that arbitration as a mechanism for dispute resolution has been with us in the industry obviously for decades, for a very, very long time. And when you look at the increase in expense, perhaps it's a sort of victim of its own success. So as arbitration has raised its profile and become more widely used, what you see is you get ever better facilities. The people who are sitting as arbitrators are perhaps more experienced, that they're coming into arbitration at a higher level. But all of it, I think, has pushed the costs up a little bit. So, you know, if you look at Singapore, you have Maxwell Chambers, which are state-of-the-art, second to none when it comes to arbitration. But all of it comes with a cost underlying. And so maybe that filters through to the users of arbitration. It's just my perception.
Okay, so I'll just follow up on that, because I do want to get a bit of, I just want to follow up with one question, because both of you, actually Kawa and Chris, spoke about SIAC. And SIAC is an administered process. You have the Maxwell Chambers, and you have the whole machine that supports you in how to run an arbitration. But whereas for SCMA is actually an unadministered process, you can decide on the level of help that you require from the organization of SCMA. So when you talk about that, then shouldn't the cost that when you go to SCMA be then lower than SIAC? And the next question I want to know is, when we talk of arbitration in Singapore, everyone, or not everyone, but most assume that SIAC is the body to go to and not SCMA. Whereas when you go to London, LMAA is the body that you go to when you want to do a maritime dispute resolution. Why is that perception, why does that perception still exist? So two questions. One, if you go to SCMA, should your costs come down? Because personal experience, that's not what I'm seeing. So I just want to hear some thoughts. Yeah.
Maybe I can try taking that one.
Yeah.
And I'm going to be a little bit provocative here, particularly to my previous profession, private practice. And I think it boils down to one word, and that's capitalism. Something we are all familiar with, I think. I think the intention of arbitration and why we had arbitration started off well. Parties wanted less complexity to the dispute resolution process, because back in the day, the court process used to take a long time. Parties wanted more certainty on cost, a cheaper process, and very importantly, parties wanted confidentiality. Now, of those three drivers, I think confidentiality is probably the only one that vaguely remains, not even in its entirety. What has happened? Through its evolution, lawyers, private practice lawyers and arbitrators have realized that there's a big business to arbitration. The fact that most private practice lawyers have their KPIs driven and monitored largely by the hourly rate does not help matters. I remember when I was a partner in a law firm, you were always asked, why are you not billing more on a certain case? Why are you not taking this all the way to a hearing? And my answer was, well, it's not in the best interest of my client. This should be resolved commercially. So inherent in the business of arbitration is a conflict of interest between how lawyers bill, how arbitrators bill, and the best interests of their customer.
Okay, thank you for that. Okay, before I move on to the next question, to the next topic, Nick, if you were given a choice of court process or arbitration, and if the subject matter can go either way, what would be your recommendation?
Sorry, I have to say it depends, because because it depends on the subject matter. It also depends on if you get a successful arbitration award or a successful judgment, where you're going to enforce it. So classically, arbitration has the edge because of the New York Convention. Awards are, in general, a little easier to enforce across the world. The New York Convention's been phenomenally successful in achieving its objective there. On the other hand, take Singapore or the English court system for the kinds of disputes that we see in maritime, pretty efficient, actually. And if you're dealing with two parties from the same jurisdiction or two blue chip parties, I might well recommend litigation in court. And there's another reason I might recommend it, depending on the nuances of the case, and that it is generally a little easier to appeal if you lose. Of course, if you win, you would prefer to do arbitration because it's very hard to appeal, almost impossible in Singapore, difficult in England, a little easier. But usually it's a principle of natural justice that you have a kind of right of appeal somewhere. And so courts generally give you that.
Thank you. So actually, that brings me quite nicely to my next question. I mean, my next topic is because of the confidential nature of arbitration and perhaps all the other avenues of alternative dispute resolution. In the conversation I had with Suyin prior to this session, she mentioned that the downside is the development of the jurisprudence of maritime law. In Singapore, under the SCMA rules, there is the finality of the award, and the courts rarely give leave to appeal. And in London, there is some limited right of appeal. So the questions are, do you think that the right to appeal would make an impact on the development of jurisprudence or encourage more parties to go for arbitration? And also given that in London, the right of appeal is also limited. So, if this is the case, do you feel that jurisprudence has stunted, given that for many years, most maritime disputes are resolved by way of arbitration? And how do we resolve this challenge? Perhaps I start with Corina. Yeah.
Yes, that's actually a very interesting question. I took a look at some statistics on our LawNet repository last evening to see what's the number of cases that have been reported locally for shipping and admiralty. And there are about 205 local cases since the 1980s. Then you see on a per decade basis what the drop is. So at the height in the 1990s, we had loads of reported decisions locally. Then in the 2000s, there's quite a sharp drop. And I think this sits in or corresponds with the introduction of the International Arbitration Act in Singapore, which was implemented in 1995 in order to import the model law, the UNCITRAL model law, as well as the New York Convention. And obviously, there's a bit of a gestation period, right? Everyone knows if you incorporate an arbitration clause today, it doesn't mean tomorrow you go to SCMA or SIAC. So I think by the time you see disputes coming to court, that's where you see the dip in the year 2000 onwards. So I think it is true that there is a drop in jurisprudence. Now, if I were to say to my client, could you please agree to arbitration because I think it would help us build our jurisprudence, I think most of my clients would just say, I'm really not interested in helping you build, legal jurisprudence. But I think that more realistically, it is important, or to me anyway, and this is my own personal view, what is important is to ensure that we get a right decision. And by right decision, I'm not saying, nobody's perfect. There are sometimes when very experienced arbitrators may even get it wrong. And that is where the right of appeal comes in. And I think it is important to import or to allow a right of appeal in Singapore. Now, I'm not advocating opening the floodgates and opening the doors wide and allowing all sorts of appeal, but a very limited right of appeal could be introduced. The Law Reform Committee actually was formed, I think in 2019 or 2020, and they concluded that a limited right of appeal should be allowed. There was also a Ministry of Law public consultation that was launched in 2019 that took soundings from the industry as to what is the preferred course or way ahead. And I think that if you look at the London experience, the English have had this right of appeal, again, a limited right of appeal on points of law since 1996 when they had the Arbitration Act. And I don't think that it is a case where it would actually affect the finality or party autonomy, which is what people are a bit concerned about. Because even if you look at the London statistics, they've had this right of appeal since 1996. But the number of appeals, permission granted to appeal, is very, very small. I think off the top of my head, last year they were looking at about 50 or even less than that. In about 16 or 17 of those cases, permission wasn't even granted. So you're really looking at a minute amount. So I don't think that in the larger scheme of things, it's going to affect things, but it is important to allow users to have that right of recourse.
So can I just add one point, and maybe to lend a different perspective to this issue? I did a brief check on Google earlier this morning, and it seems that of the cases referred to SIAC, about 60 to 65% had Singapore law as governing law. If you look at LMAA, I believe it's about 70 or above 70% of the disputes referred to the LMAA had English law as the governing law. So just a brief 5-minute search suggests to me that a strong correlation between the governing law of a contract and the seat of arbitration. So if we bring it back to the question, how do we build Singapore as an international arbitration center for maritime, and where does the jurisprudence come in? I think you're seeing this in the correlation. People have to choose a governing law of their contract first, and they need to trust that governing law or have an understanding of how their dispute may be resolved under governing law. To use the statistics presented by Karina, 205 maritime and admiralty cases over 40 since the 1980s, so 40 over year period, is actually not a lot. Whereas when you compare it to English law with a great body, much larger jurisprudence, even though they've had a limited right of appeal since 1996, arguably there is a much larger body of decided case law that people can refer to in order to build confidence and understanding of that legal system. So I just think it's food for thought as we think about the role case law and jurisprudence has to play in promoting a country as a center of arbitration.
Actually, just an interesting note, for maybe this panel, but in the 1990s, the number of cases was 88. And then in the 2000s, we're looking at 55. And then in 2010 onwards, we're looking at 48. In 2020, we've only got 14.
Oh, that's really...
So you see the trend, it's really dipping.
Yes.
Yeah.
Any other thoughts?
Yeah, if I may just chime in. I feel that it also is the sophistication of disputes parties, right? Because I think in the 90s and the early 2000s, a lot of it is if you have a case, you fight. But I think that now, today's day and age, there are lots of intermediaries before the case comes to the lawyers. Right, so just also to touch on Soo Yin's point about lawyers being the fee hungry and KPIs of billing, but I think that has changed in a large way because, like I said, there are lots of intermediaries. Would you think that the large in-house teams, right, the GCs, the P&I clubs that are also looking at the cases and underwriters would allow lawyers to just run away with the legal fees? I don't think so. Not today, right? Plus, that's competition. The competition drives the rates and the fees down. The conditional fee agreements that are now in place in Singapore, I can also see further downward fee pressure. So I think that lawyers would not be in a comfortable position to say that I will continue to just keep billing, right? But I think that is an issue that also structurally, the rules of court has addressed. The new SCMA rules are also addressing that point. So I think a lot can be done by the tribunals now to follow through on these rules like managing cases. I think case management will be a big thing to help parties reduce the issues to just the core issues that are in dispute. Witnesses, experts, everything reduced to just the essential ones that are in dispute. Those are how I see arbitration taking shape in Singapore to head towards a very cost-efficient and probably practical for parties to want to come in. And in terms of, like I said, jurisprudence, it's not that we don't have cases. We have very good cases. I tell you in what areas. Arrest of ships, we are very good at doing that. Right? So our arrest jurisdiction and case law is right at the forefront of all the common law jurisdictions. I can't even imagine, are there any arrests of ship cases coming out of London, right? But we are also very good in forum shopping. So a lot of people want to come here and forum shop. So stay, forum jurisdiction, jurisdiction clauses, forum non-convenience. We are very good at that. We've got very established case law on that. And I would also say misdelivery. We are very good at misdelivery because a lot of the time, right, delivery without production of original bills of lading and all the effects of it, the legal, we are very good at that. So it's not to say that we don't, and we have a spate of collision cases as well. It's not to say that we don't have cases in Singapore and that we are stunted by maritime arbitration. There are cases in Singapore. It's just that I feel this appeal route is already discussed by my fellow panelists. I think that the appeal route can be addressed. It can be addressed.
Chris?
No, I, for my own part, I think that the right of appeal is important, and I think it does give London an advantage at the moment. And I think it's something that Singapore would benefit from. I think the point that you made about having extra jurisprudence is absolutely correct. I mean, what Kawat is saying is correct for things like ship arrest, but when you look at bills of lading and charter parties, almost exclusively they're arbitration. And if there are going to be cases going to court on those, there are always going to be appeals from arbitration. I think that a lot of, in my experience, you get big businesses who are based in Singapore will still put London arbitration in because of that right of appeal. They have the money to spend if needs be, and they don't want to be on the wrong end of an arbitration award. I think nobody wants to be on the wrong end of an arbitration award, but it's nice to have the comfort of an appeal in the background. On the issue of cost, people don't always appeal. You know, you will look at it and you will assess, but to have that ability to appeal, I think, is important. Whether it will immediately improve the amount of jurisprudence coming out of the courts in Singapore, I think the answer to that probably is no. And the reason for that is when you look at how many arbitration awards you have to have, a percentage of arbitrations won't even go to an award. Of those awards, very few will actually be appealed and find their way through into being reported court cases. So in order to get that body of jurisprudence, you have to have thousands and thousands of arbitration awards because the percentage that gets reported is very small. But unless you have that right of appeal, you don't even start on the journey towards getting that. So I think, however you look at it, it's positive for Singapore if you had that right of appeal.
Yeah, some food for thought, because the declining trend is actually quite worrying. Yeah, and is the right of appeal the only way to promote, to actually develop the jurisprudence? Anyone has any thoughts on how do we actually, yeah, Chris?
The other aspect of it, I suppose, I mean, if you want your court judgments, then yes, I think you have to have the right of appeal. The other thing that you have in London, which I think is quite helpful for practitioners and users of arbitration, is you have the Lloyd's Maritime Law newsletter. So obviously you've got your court cases, which make the law and they're the jurisprudence, but to have the guidance from the law newsletter is also quite a helpful thing. But again, in order to have that, you've got to have the volume of cases in the first place, because as we all know, arbitration is private. If you have an interesting arbitration award, the parties involved may agree that it be made public, you can redact names and so on, but you've got to have that agreement in order to put it out there. So again, you've got to have a lot of awards in the first place because only a very small percentage will agree to put them into the Lloyd's Maritime Law newsletter. If you've lost, usually you don't want to go public with that.
Yeah, thank you for that. Yeah, okay, I only have 12 minutes. Okay. I'll go to the next two areas of discussion. What are the challenges to Asia's maritime arbitration, and what are the practitioners' views and solutions? And the next related one is choice of jurisdiction and the Singapore advantage. So I think we have touched on that in the earlier questions. But in conversations with some companies, when asked for a preference for LMAA or SIAC/SCMA, a majority have expressed a preference for English law and LMAA. The other common refrain is that dispute resolution clause is usually not a clause that one concentrates on when you do negotiations. And once settled, you actually have the last done effect. So perhaps I can get Nick and then Suyin to share that in their contracts with counterparties, is it primarily English law and LMAA? And let us know, I mean, of course, why the prevalence?
Yep, I'll start. I think that there is a last done effect. We're a conservative industry, and so you do see a lot of LMAA English law, but increasingly I am seeing SCMA with English law. And in fact, my team, that's what we promote. And that's great, you preserve your right of appeal. The SCMA rules, which have been recently revamped, are frankly state-of-the-art. If you're in Asia, like now the majority of shipping companies, it's very sensible to have the venue here. You can pick your own arbitrators. The quality is very, very high. And I can report that actually if you have a negotiator on the other side who's pragmatic, you spend certain amounts, small amount of negotiation capital on the midnight clauses. This is a midnight clause because it's usually decided at the last minute. But we do spend some time trying to promote SCMA, sometimes without success, but more and more with success. Even, I'm glad to report, on non-marine related matters. Only the other day, we were doing an acquisition. Very pragmatic counsel on the other side, from New Zealand actually, heard of the SCMA, spent time in Singapore. Yes, makes sense, absolutely. So it's a matter of proselytizing and time, and this is a long game. The economics are shifting to the east. It will happen.
Thank you. Suyin?
I agree. And maybe just to lend some context, so far we've been talking about the issues, but I think we do need to take a moment to just acknowledge and celebrate that Singapore is actually the second most used arbitration jurisdiction in the world, and the top preference for arbitration jurisdiction in Asia Pacific. So I think more and more we are seeing that parties are keeping an open mind to having their seat of arbitration in Singapore. In the maritime space, SCMA is having an uptick. But I go back to the fact that you do still see people insisting primarily English law. But I mean, in terms of the seat of arbitration, Singapore is doing quite well.
Good to hear. Yeah, good step forward, good step forward. Small steps, small steps. Okay. So the mindset is that just now Nick said about the last done effect, and then the dispute resolution clause is not one that is of main importance. Is there any way to change this mindset? I mean, you spoke about that earlier on. Is there do we make a conscious effort to always look at the clause and because Singapore is actually very rules-based, there's a lot of neutrality. We are known for our neutrality and rules-based, and especially when the parties are based in Asia. How do we encourage the adoption of SCMA and the seat in Singapore?
Well, as I said, I think a lot of it is education, and it's a long-term game. Yeah. One thing you can do, of course, is take the approved clauses, which are easily available on the website, or BIMCO clause, and this might bring us to the next topic, but I'm a huge fan, as I think a lot of people in Singapore are, of the ARB-MED clause, standing for arbitration, mediation, arbitration, which encourages strongly the parties to think about and then deploy mediation after you've commenced an arbitration. Not that you have to do that. You can have mediation any time. And I think Singapore is beautifully positioned to take advantage of the growth of mediation. And in fact, I see things evolving historically along these lines. First of all, the king decides. Secondly, you have trial by combat or ordeal. Then the next stage of evolution is heavy litigation, American style, which is where we are now. Then arbitration, which actually started in Liverpool as a result of the cotton problems in the American Civil War. But now, modern way to resolve disputes is ADR, mediation, mutual evaluation, early intervention. And I do think in the East we're well positioned to take advantage of that. And anyone in this room who's been involved in mediation, well, I think 90% of you who've been involved in mediation will have had a good experience. It is cheap, it can preserve the business relationship, and the management time devoted to it is minimal compared to going through the awful pain of a long arbitration or litigation. So I may have jumped ahead on the topic, but I appeal to everyone in any dispute to consider mediation, not just halfway through the arbitration, but actually earlier than that.
Thank you. Hold that thought. Because Corina wants to come in on this. No.
I just wanted to make a point just now when you were asking Nick about what it would do, what could be done to persuade people to change their minds as regards the arbitration clause. And I was going to say, I think a lot of clients actually say that it really depends on the bargaining position of the other party, right? I mean, if you've got a big company, I don't think the small guy is going to be able to persuade him to change his standard clauses.
Maybe if I can just add one point on that. I think we discussed this in our pre-panel discussion. I think it starts local, because when I look at the Menon report details that you put up under mediation and finance, arbitration and finance, you had, I believe it was New York, Tokyo, and up there you had Oslo and some strong maritime nations up there. And I think what's driving a lot of that is that companies incorporated in those countries push for having disputes resolved in those countries and under the dispute resolution mechanisms of those countries. I think, places like Japan, Norway are helped by having a very, very strong set of local blue chip shipping companies who probably have the bargaining power, to Karina's point, to push for those in their contracts. But I think in Singapore, I think one appeal I would make to the Singaporean business owners in this conference here today is push for Singapore arbitration in your contracts. Push for Singapore as a governing law, because it starts with the local businesses to start asking for it. Because if you go to an MNC or an international company, there are different considerations surrounding governing law and dispute resolution clauses.
Just one point to make with that as well. If you're trying to move away from London to Singapore, it's not a snapshot in time, it's an ongoing process. So if you push hard to have Singapore arbitration put in your contracts, the first experience you have of Singapore arbitration has got to be a positive one, because when you're changing and moving towards something, if you don't like what you've just had, you're going to go back to it. You're going to go back to what you had before. So it's the people involved in arbitration here, the arbitrators and everybody else, the lawyers and all of us have got to make sure that Singapore delivers, because experience will always trump marketing. And I think Singapore is very, very good at the marketing of its arbitration offering, but the product has to be good. And I'm not saying that you will always get a perfect experience in London, but if you get a bad experience in London and you haven't changed, well, it was a rogue, whereas if your first experience of Singapore is bad, then you're back to London and you've missed that chance.
Yeah, so important, yeah.
Add something to what Chris has said, because I think that's a very important point. I have often heard comments from users that after following an arbitration in Singapore, they said, the tribunal, the arbitrator was horrible. We obviously didn't even know one end of a ship from the other. And it leaves them with a very negative impact. But I think when you dive a bit further and you try to ascertain what kind of circumstances or what kind of matter they are talking about, you then realize that they actually, unfortunately, had chosen the wrong set of rules. So with the wrong set of rules, you have the different panel of arbitrators, and it affects the whole complexion and the result. And I think that's really important. So for example, for SCMA, there's a curated panel of arbitrators, about 128 from 19 different jurisdictions. You've got technical people, you've got lawyers, you've got arbitrators. You take your pick, but everyone would know something about ship in their expertise. So I think that's a very important fact to bear in mind when choosing which set of rules and choosing which arbitrator that it is that you want.
Yeah, so which brings back to the point of what Chris said. Actually, the whole legal fraternity needs to get their act together, because the company is not going to know who are the lawyers to choose, which are the rules that is going to apply to me. So in that sense that the maritime legal fraternity, the maritime legal sector needs to have that in-depth knowledge and needs to know what they are doing before they give that recommendation to the parties who are going for arbitration.
Yeah, maybe just one point on that, just to tie into some of the questions that have been asked here. It's not only the maritime legal fraternity. I think the expertise goes beyond that, because oftentimes for charter parties, your lawyers are not really involved in negotiating the charter party. The shipbrokers have a part to play, and I will also say insurers have a part to play. All the risk managers and commercial parties involved in the contractual chain need to align on, okay, maybe we need to start pushing for Singapore as the jurisdiction or having disputes resolved here. So to go back to what I believe it was Julian Proctor said in the first panel, it's the narrative behind it. And we all need to align on that narrative.
Yeah, just Caroline, if you don't mind, I think that on what Chris shared about the experience of having an arbitration here, I think there's one piece that is critically missing, which is a review process or a ranking process of the maritime arbitrators that are in this space in not only in Singapore, but any part of the world, right? I think that Singapore needs to have a structure, and I think that this structure is to rank our maritime arbitrators. I've heard many stories, in fact, I've experienced that myself. Arbitrators are overbooked, because they always go back to the same few experienced arbitrators to helm these cases. They are booked right up to, I think, a couple of years, sometimes in advance for their hearing dates. Arbitrators are not on top of their cases because of the workload and their schedules, and arbitrators are charging, right, too much, right, for when they are involved in just that tail end part of the case, and arbitrators take too long to write their arbitral awards. After the case is over, they can take up to 3 months, 6 months, some even longer than 6 months to write their awards. So I think that if the Singapore fraternity is serious under SMF, maybe even under MPA, there could be a ranking service or ranking submissions for users to bring submissions and feedback, constructive feedback, and then we will know who these arbitrators are performing very well, who the arbitrators are not performing, and feedback can be given. And once the feedback can be given, I think we can distinguish the serious players from the rest. So I think that is one way in which I suggest we can take this forward. From that review process, it will sharpen up our game.
Thank you for the suggestion. Really food for thought. Yeah. So mindful of the time, because I do want to go to the role of mediation, and I do have questions. So I'm going to take a bit of everyone's time a bit more, because I do want to discuss, because in the Menon report, and Nick has advocated for mediation quite strongly. It did say that the area for improvement for maritime legal landscape in Singapore is for Singapore to focus on mediation as an alternative remedy for resolving disputes. And actually, everyone has shared, in my pre-panel session with them, everyone has shared that the benefits of mediation are manifold: cost, process, and most importantly, the preservation of commercial relationship between the opposing parties. And the common phrase I always hear is always up first, met, then up. And it connotes to the companies that when there is a dispute, you commence the arbitral process. Then you pause after the issues have been clarified, and you go for mediation. And then if successful, you go back to the arbitration, you close the arbitration process, and if not successful, then the arbitral process continues. And actually, Nick, who also chairs the BIMCO Documentary Committee, shared with me the new clause on ADR to provide parties with an early intervention or a neutral evaluation process before commencing to arbitration. So it's then met, then up. It's talking about early intervention. So, Kawa and Chris, do you think it's possible to start with mediation without crystallizing the issues? Nick?
I do.
Okay.
I think it's often used as an excuse by law firms to say, let's crystallize the arguments. By that stage, positions have hardened quite a bit. You may have to go through the horrendous discovery process. But mediation can be done at any time. You can do it then, or you can do it earlier, at which point you've saved a ton of costs. And the clubs have been excellent at promoting mediation and promoting early intervention, which is similar to mediation, but over a longer period of time, starting earlier in the process, a mediator picking up the phone, shuttling, not in a 1 or 2 day period, but over a number of weeks to address this very issue. I think it's an excuse. It's easy to say, let's crystallize the issues first. I do think you can resolve things without knowing the nuances of all the arguments earlier on. And of course, you're potentially preserving business relationships more easily. And in our industry, of course, we come across the same owners, charterers, commodities folks, and so on. So I'm an enormous fan of mediation, of which early intervention is a part. Neutral evaluation is where you appoint somebody who will give you an early, quick, and dirty idea of how strong or weak your case is. So that's not quite mediation, but it perhaps makes you understand a bit better the weaknesses of your case.
Thank you for that, Nick. Chris, do you have a view?
I agree with Nick. I personally am a big fan of mediation, and I agree it can be started at any time. And I think if you started early, both parties have got in their mind a very clear idea of what led to the dispute anyway, because they were involved in that transaction. And if that early intervention doesn't work, it will identify where the problem lies and what the facts are that need to be resolved and looked at. And as Nick said, that we think of mediation usually as a sort of one-day get-together, but the process can develop over a period. And I think mediation, I'm just conscious of one of the questions on there about Singapore promoting mediation. My own personal view is that mediation exists as a thing, and it always has done, and it's there to be used by anybody at any time, and it's down to the practitioners, the lawyers, to recommend that. And I think increasingly in-house lawyers and you know, people are savvy and they know it exists, and so you're missing an opportunity. We've talked about the cost-saving benefits, but also from a lawyer perspective, what I see is you're sort of giving the client that last chance, you know, before you go to arbitration, the hearing, and it's out of your hands. The mediation process is quite empowering for the client because it gives them the chance to reach agreement. They may not be happy with it, but it's their decision and they take control of their dispute again. And if you miss that chance, then it's a run into an oral hearing, disclosure, and all that expense. So mediation, I'm a big fan of it, but Singapore, all you need is to promote it. It doesn't need any more than the lawyers to take charge and promote that. And the key is good mediators. That's what you need to have successful mediation, I think.
Okay, so hold that thought about good mediators. I want to hear thoughts from Corina and Kawa that given that mediation is supposed to substantially reduce the costs and time of a legal dispute, do you think that it will be promoted by the lawyers who will not benefit from a lower cost of dispute resolution? Or do you think that the tide is moving, the train has left the station, we all have to get on it?
I think that's a trick question. But seriously, I am a big fan of mediation as well, because I think it does serve the client's interests. Yes. I would always, even before mediation, the word mediation became sexy, I always advise the clients to look at commercial realities, because you often see clients who are so entrenched in it and they always tell you that they want to fight as a matter of principle. And I always say to people, please take one step back and think properly, because principles cost money. You know, don't tell me after you've lost money, then you'll turn around and you tell me, why didn't you tell me earlier on, right? Sure. So it is a very expensive lesson sometimes. But coming back to your question is, yes, I would always, if it is in the best interest of the clients. And more recently, the courts have actually implemented, because we've just revamped our rules of court, there are new practice directions which took effect from the 1st of April this month, which basically require counsel to complete a questionnaire at the start of the proceedings very early on, and then you need to confirm that you've discussed ADR with the client. So there's no way of escaping it now, whether, you know, because you don't like it or it's going to eat into your billings. So
Good to know.
that's
Good
a
to know.
Yeah,
Yeah.
good way forward.
Yeah. Kawa?
Yeah, a slightly different perspective. I think for commercial parties, right, with a relationship with your other half, commercial cases, I strongly recommend that mediation will be the route, right, even at its early stage. But not all proceedings, right, not all disputes fall into that category, right? Some disputes are just, you have to look at the case and you just have to ask yourself, is it suitable for early resolution via mediation? That's why some cases are, when we see it, we will tell you that. It's not a one size fits all. That's my point. Second point is that there's still this inherent concern that if you suggest mediation too early, it can be seen as a sign of weakness, that you are fearing that you are unable to substantiate your position, and you are not even thinking about at least filing or putting your cards down, and then you want an early resolution. So that is the second one. And then down to the third, lawyers will always welcome additional levels of dispute resolution. Why do I say that? There's also a good chance that it may fail. So when it fails, right, we can also say, look, you know, we've tried, we failed, and then now let's go and make some more money via the arbitral process or via the court process. So in that sense, yes, yet another layer for us. I don't think lawyers would feel that it is, you know, hindering their own earning capacity in that sense. Although I say a lot of the times mediation is successful from my personal experience after parties have fought some initial firefights. And from the initial firefights, they can feel that perhaps the full brunt of litigation or arbitration is not the correct strategy, and they now feel that, okay, perhaps it's ripe. It is at that stage that I've seen higher success rates in terms of mediation outcomes.
Thanks. So I want to go to the questions on mediation. There are quite a few questions on mediation. There's two that's actually connected, and also bringing the point that Chris mentioned just now on good mediators. So it says, okay, it's not tapping. Oh, okay. So it says mediation has been said to be in its infancy stage, and it will take some time before it catches up with arbitration. Is this still true? From the conversation I have, it doesn't seem true. I think mediation has taken on, is gathering momentum. And then also the next question, which says, who would be the mediators? Would mediation go the same way with costs rising too? So then we talk about the Singapore Mediation Centre. Is it known to the maritime industry? And do we have good mediators? Because Chris also mentioned about that, just let the lawyers take charge. Do we have good evaluators? Do we have a neutral evaluator, that the pool of evaluators in Singapore? Kawa? Or Chris?
Okay, I think that being on the mediation train since 2012, being very supportive of Singapore mediation, I think that we have a very strong pool of mediators, right? If you go to the SMC, the Singapore Mediation Centre's website, as well as the SIMC's website, they have a specialist list as well of the maritime and shipping mediators. So I think that in terms of accreditation, training, right, we are quite well equipped in that sense. We have good support as well for mediators, and that I think the only challenge I see is that because a lot of the mediation practitioners, we practice this is a non-evaluative style of mediation. So we try to bring you to a settlement without going into the merits of the cases. So it's a non-evaluative, interest-based mediation style. So parties may feel that it is not a very principled way of resolving a dispute, but we look at other interests like commercial interests, cost benefit, etc. Then the other style, which is more evaluative, which is to really look at, and you want the mediator tribunal or the mediator panel to express a view, even if it is a non-binding or a soft view. So that is the other style. So you can actually go and request for your mediator according to the style of mediation that you would like, an evaluative one, which actually helps parties at least go and understand where, from an objective person looking at the case, what are your strong points and what are your weaknesses, and how does the case appeals to that mediation tribunal. So I think that is the other style of mediation that is catching on now.
Caroline, could you help us to wrap up soon? Thank you very much.
Okay.
Thank you.
Sorry, I've been told to stop. All right. Okay, there's two questions here that is totally unrelated to what we have discussed before, but because tomorrow is talking about maritime talent, so I want to speak about the maritime legal talent. And there's two questions here. The first question that has 5 votes, it says, the availability of expertise would be important to bring more dispute resolution in Singapore. How can we encourage the young to join this sector? And the next question that has 3 votes, it says, some young lawyers and law undergrads have said that maritime law is a challenging specialization. What do you have to say to young law undergrads on why maritime law is worth their time? Okay, I'm going to open up to anyone. Yeah.
Maybe I'll start.
Yeah.
I think one needs to have a passion if you want to do maritime law, and that's what I always tell the young lawyers who join me or join my firm. I keep telling them that if you actually look at just dollars and cents, it's not going to work for you, because I think people that do other types of work, like the DCM markets, the IPOs, the corporate mergers, acquisitions type of work, they probably bring in a lot more revenue in that sense. And it has an effect as well, because eventually when you get more senior, and if that's the book of your business, obviously your income will be much more than that. The second thing is, gone are the days where, like when I started in the 1980s, you could just specialize on shipping and there was enough work to do. I think nowadays with the growth of in-house legal departments, especially at the P&I clubs, a lot of work is actually done in-house. So when you say you specialize in shipping, a lot of us, I mean even Kawa and Chris, I'm sure, we do slightly more than just shipping alone. But again, I always tell the young ones that if you don't know how to do shipping, you cannot call yourself a shipping specialist and you can't do shipping work. But if you do shipping, you can still do broad-based commercial litigation, because the tools that you have actually acquired, the skill set, it's still there and it's more flexible. And I think it makes you a better lawyer. And it is interesting. I mean, I've done it for many, many years and I can't imagine life, without a ship.
Yeah. Anyone else? Another, yeah. Nick?
Yeah, this is the key question for the future.
Yeah.
And it is hard, but it is as we know in this room, it is the most international, the most satisfying industry to be in. And once they're in, shipping doesn't leave your blood system.
Yeah, that's right. That's right. They say you cut and you
I
have
would just say to that as well, when you look at the panels that we've had that went before us, what being a shipping lawyer is in the future is going to be very different to what it was in the past. When you look at, decarbonisation and digitalisation and all of the legal issues that will arise out of those, they'll still be shipping lawyers, but they'll be dealing with a multitude of new issues that, you know, people, they'll be finding their way, making new law, new things, and it is exciting.
Yeah, and I think if I can just add to that, I think to me it's always about the branding, the marketing, and the sell. And people need to understand why is shipping relevant to them. People join banking because they can see the relevance. Same with finance, same with tech. I think it's very important for us to be able to sell our industry. You know, maritime and supply chain is not just, you know, blue collar workers in their overalls working. Actually, it's the bloodline of international trade. And it's what actually keeps the world flowing. It's what gets people their iPhones. And I think once you're able to tell them why this is relevant, attach it to their purpose, I think that's one way of growing it. And I think secondly is role models. In this industry, regardless of whether it's maritime law, it's just all across the roles in the maritime industry, we need to go out there and we need to role model to the next generation why this is such a great industry to join.
There you go, all the reasons for joining the maritime industry. Yeah, so takeaways. First is mediation should always be the first step to dispute resolution. And Singapore still, it is a journey to being the, to go alongside London as a preferred centre and to have more cases. The right of appeal, the ranking, I think these are all food for thought. So I hope you find this discussion as insightful as I did. And please join me to thank our panelists for sharing with us today.
Thank you very much, Caroline, our panelists. Can we invite our panelists to please rise as we take a group photo together? Please, you don't have to wear your mask yet. Yes, yes. Step forward. Thank you very much. Yes. Thank you. Can we have a photo that's apart as well, so that it's for publication? Yes. 1 meter apart, please. Thank you. Thank you as well. Yes. Yeah. That one is for sentimental. This one is for official. Yeah. Thank you. Big hand for our panel, please. Thank you very much. Thank you very much, Caroline. Thank you very much to our dear panel.